I want to give you a quick overview of an offer package, the purchase and sale agreement. Now, you may have at some point had the opportunity to review these forms in the past, but there's a lot here. And so I just want to give you an opportunity or an overview again of these forms. Now, this is going to be a general overview. Every property is different. Every circumstance for a buyer is unique. So some of these forms may or may not be part of an offer that we're composing for you, but this will at least give you some familiarity. And of course, you're encouraged to review and read everything when you're signing it. So this is what I like to refer to as a summary page of the purchase and sale agreement. It's the very first page, and it lays out all the specific terms of the purchase and sale agreement. So the date of the agreement, that it's written, the MLS number if it's listed, the date that it expires. It's important to have an expiration to your offer. You don't just want it flying around out there for a seller to accept at any time. We want to have an expiration to that. The buyer's name, seller's names, the property address, tax ID, and most importantly, we want to make sure that we attach to this agreement the legal description of the property, the lot block description, like lot 3 of subdivision such and such, so that it's adequately described. It is required to have a binding agreement. If this were to go to court, God forbid, they would not hold it as binding if it doesn't have a legal description attached to it, so everybody understands what was being bought and sold. Okay, included items. So there is a paragraph in the boilerplate of this purchase and sale agreement and a subsequent page that talks about what is the real estate. And generally, it is anything attached or installed in the home, to include fixtures like plumbing, electrical, appliances that are installed in the cabinetry, even things that are outside that are in the ground, like the roses, those are part of the real estate. Some things get confusing, and some things are actually personal property, like a washer and dryer is just sitting there. So it's actually personal property, but sometimes it actually conveys with the home and with the purchase of the real estate. So we just want to be very specific here. Doesn't matter what they advertised in the listing. If it's not in the agreement, it does not exist. So we want to make sure if there's anything that you are curious or not clear about, let's talk about that and make sure that it is clearly specified here. Okay, our offer price, and then earnest money. Now, earnest money is a negotiable piece. You can offer an amount of earnest money. It goes towards your purchase in the end, and it's well protected by several of the contingencies that we've put in place here in the offer. But you make that offer, and it can be negotiated. The seller could come back and counter with a higher amount of earnest money. Okay, that earnest money usually is held by an escrow agent at the title company. That's what we're specifying here, that is held by the closing agent. Now, what happens if you default? As the buyer, if you default, we have two options here. We favor the forfeiture of earnest money option. And what that basically says is, seller, if in the end I don't conclude with this sale and this purchase, and I don't have a legal reason to terminate, and we've got several reasons that we build into our contracts to protect you and your earnest money. But if in the end you fail to purchase and it is considered default, then seller, you get my earnest money. I forfeit my earnest money. Now, the alternative is this seller's election of remedies, and what that basically means is that if you default, seller doesn't just immediately get your earnest money. They would have to take you to court and prove that you damaged them. Okay, and the problem with that is anytime you go to court, it gets expensive, and there's a possibility it could get way higher in dollar figures than your earnest money actually would be. Earnest money doesn't typically exceed about 1% of the purchase price. So it really is best for all parties, in our opinion, that there's an understanding of forfeiture of earnest money is the remedy in the case of a default. Okay, title insurance gets ordered and applied to the title of the property to protect you, the buyer, and give you clean title. We like to use Chicago Title on a pretty regular basis, but there's lots of great title companies in the area, and we may or may not end up using Chicago Title depending upon how the other party feels about a title company, who they want to use. Maybe they already have done some preliminary work on the title with a particular company. So any title company is going to do a good job. Closing date, we'll specify a closing date. It is a hard and fast date. Now, it can be changed, but only with written agreement between both buyer and seller. Otherwise, that is the date we are going to close. You're committing to that. The seller is committing to that. So we want to make sure we pick a date that works for you, but also works for the lender if there is lending involved. Because the lender needs sufficient time in order to get all of their underwriting, appraisal, and everything done in that time frame. Okay? Closing is not when you go and sign documents. It's not like on TV. You'll actually oftentimes go and sign documents or have documents sent to you or have a notary come to you a day or two in advance of the closing date, because we need those documents signed back to your lender so that on the day of closing, the lender's prepared to send the funds to escrow so that escrow can record the transaction, record the new deed in your name at the county. And that's what closing actually is at recordation, okay? Then possession occurs. Possession's when you can actually go in with your keys, it's your property, okay? That we usually try to make 5 p.m. on the date of closing would be the time that you can take your keys and access the property. In some cases, sellers, however, they logistically need a little additional time. They need to close on the sale to you and then get the proceeds from that sale to then subsequently close on their next home. So that can extend or delay your possession by a few days to, in some cases, even a few weeks. And there are implications involved in that. So we would have talked about that at more detail in your particular circumstance. But generally, we try to get you possession on the same day that it is recorded into your name, okay? We're going to ask the closing agent at the title company who's settling the transaction to also settle the utilities bills that serve the property, but only those that have lien rights. Lien rights would be if a bill isn't paid, they apply a lien, or basically the bill gets attached to that property. No matter who owns it, they are responsible. So we don't want you to be responsible for anything that wasn't your doing. So we want to have the closing agent settle those bills at the closing table from the seller's proceeds, so you start with a clean slate. Now, most utilities don't have lien rights. The ones that generally do are cities, like City of Olympia, Lacey, Centralia, wherever you might be, that might serve water, sewer, garbage, even electricity in some cases. They would have lien rights. But cable companies, telephone companies, even Puget Sound Energy in our region does not have the right to place a lien against a property. Okay? Charges and assessments levied before but due after closing. So an example of this would be, say you're in an HOA, or the home is, and the HOA decided they're going to do a project of building a child's play set, in a community area, and everybody has agreed, voted on it, and approved it, and it's going to cost every homeowner $3,000, but they're not going to collect that until next summer. Well, that's levied now, but due later. That's an example of that. And what this says is that the closing agent, if that is made known and the seller is required to make that known, or if it's recorded publicly, then we're going to make sure that the seller pays for anything like that at closing from their proceeds, because you weren't part of that agreement or plan. Now, that could be negotiated as well. Seller might come back and say, hey, this is happening, just so you know, you're going to have to pay that next summer. It isn't a hard and fast rule or anything. It's a negotiation. Rarely is there something like this that comes up, however. Seller's citizenship. So FIRPTA stands for the Foreign Investment in Real Estate Property Tax Act. And in a nutshell, basically, anyone who is not a citizen, anyone who is a resident alien, if you will, they may owe taxes at the conclusion of a sale if they're the seller. Again, very rare does this come up, but it's important that this get declared and handled properly so the escrow agent can collect those taxes, because we don't want the IRS coming to your door later on saying, hey, taxes weren't paid, because you'll be much easier to find than the foreign person is. Disclosure of agency. So easiest way to think about this and the terminology of it is the listing broker listed the property, they represent the seller. And so therefore the selling broker represents the buyer. And then we have this addenda line. This is really just for administrative purposes, so we kind of have an idea of what to expect to see in this purchase and sale agreement. These aren't binding. In fact, we can have other addenda attached to the agreement, signed by both parties. They get integrated into the agreement. They don't necessarily end up on these lines, but this just gives us an idea of what we're going to see in this purchase and sale agreement. And then everybody signs and provides their information down here. Okay, so again, that was the summary page, the first page of the purchase and sale agreement, and all the subsequent 4 pages are all the long legalese, the very detailed explanations of how everything is to be handled, how closing is to be handled, delivery of documents, computation of time, how we're going to compute days, business days, non-business days, deadlines, electronic signings, integration of other documents later on down the line. It has a clause about attorney's fees in the case that this goes to court, God forbid. And again, I've yet to have any of my clients end up in court, but this is an important provision that says parties, if there's a disagreement, handle it outside of court. Because if you go to court and you lose, not only do you lose, but you'll also be having to pay for the other person's attorney and court fees to defend themselves. So this is a great clause that you should have in any agreement that you sign. Talks about offer and counter offer process. Generally, we've got the offer that expires at a certain date. If a counter offer is issued, then usually that's good for a couple days, but they can specify a specific expiration. The thing to be aware of, the important thing to be aware of, is that nothing is binding until both parties have signed agreeing to all the terms unchanged, and it's been delivered to all the parties so that everybody has a copy. Until then, any offer or counteroffer can be withdrawn at any time. So just because you get a counteroffer doesn't mean the seller needs to sit around and wait for you to respond to them. If they get a better offer, even in the next hour or two, all I got to do is withdraw their counteroffer and take that other offer. So we want to be mindful of timing and get things done as quickly as possible. Okay. Talked about agency disclosure. Commissions. So commissions are already pre-planned, right? The seller put the home on the market. They're offering compensation to their broker and the cooperating broker who brings the buyer. You as a buyer will have an agreement with your broker for an amount of compensation that they expect to receive in the case that you conclude with a successful purchase. And hopefully the desire is that the seller's offer of compensation is equal to that. If it falls short in any way, then your broker is going to be talking to you about that to make sure that when we make the offer on your behalf, that part of your offer has a provision for the seller to make up that difference between the amount that your broker deserves and the amount that the seller is offering as compensation. And every circumstance is very unique. So again, that's a discussion that you would have with your broker if that were to come up. Okay. And then property condition disclaimer, just basically saying, you know what, can't guarantee that this is the perfect property for you, suitable for you, that it doesn't have issues. You need to do your due diligence, hire inspectors, and make sure that you're fully comfortable. If anything, we lean toward the side of ready to pull the plug on this and cancel and get you out of this at any moment that you need to, that you feel uncomfortable. Because once this is a done deal, once it's closed, it belongs to you. And so we'd much rather give you every opportunity to get out than to push forward without you feeling comfortable, okay? So that's the purchase and sale agreement in a nutshell. Now let's look at, and we'll skim through the addenda that may or may not be attached depending upon the circumstances with the property or for you with the way that you're financing and such. But here we go, financing. This is the financing addendum, and we're going to lay out the type of loan that you're going to use, the amount of down payment. The reason we specify the amount of down payment is it's a limitation, meaning if your lender has said, I can get you a loan with 5% down, great. If you can't get that loan in the end after a good faith effort toward getting that loan, and then the lender comes back and says, well, shoot, I can get it for you now if you can put 10% down. Well, we've specified in our agreement to the seller that we are only intending to put 5% down. So if we can't get the loan with 5% down, we're not obligated to purchase. We can terminate. We can get our earnest money back because, again, as a reminder, any contingency or condition or subject to in our agreement, the whole intention of that is to protect your earnest money. Because again, you could walk away at any time and leave your earnest money on the table for the seller. That's absolutely an option, just not a real desirable one for most people. As part of your financing, there's also going to be a process where we have to give information to the seller at particular times in this process, to give them an update on what's going on with your loan. And at some point, the seller may come to us, as is their right, and say, okay, you've had your time. Now you need to either waive your financing contingency or risk us terminating on you if you're not comfortable enough to say, hey, I'm good with my loan, and now my earnest money's on the line if I can't get my loan. So usually we plan for plenty of time for that to be accomplished between you and your lender, so that you can get to full approval before having to face the potential of removing your financing contingency. Okay. We may, in certain circumstances, be negotiating to try to get the seller to pay a portion or all of your loan costs. Okay, this totally depends on your cash position, and we will have discussed this with you in advance. But this is where we specify that, and we have to understand that the seller has their own costs on their side. I mean, in general, a seller's costs are roughly 8% of the sale price. So in addition to that, we would be asking, if the circumstances warrant, we'd be asking them to pay, in addition to their costs, to pay your loan fees as well, which is an additional burden, or essentially it's reducing the net proceeds to the seller in the end. So if you're in a competitive situation, that will likely make your offer look less desirable than another offer where they are paying their own closing costs and not asking the seller to pay their closing costs. But sometimes that's just a circumstance, and the only way a buyer can potentially or feasibly purchase a property. Okay, your earnest money is protected by this financing contingency, and one of the major elements of financing is appraisal. The lender wants to know that they aren't lending more than what the property is worth, by way of the opinion of an independent appraiser. And so they're going to order an appraisal. And this talks about how we proceed in the case that the appraisal is less than what has been agreed to as the purchase price. There's a whole process that ensues then, and we'll guide you through that if we get to that point. Doesn't happen too terribly often, because in most cases, the real estate broker representing the seller has done a good job of advising the seller as to what the value is. You likely, as a buyer, have compared with everything else on the market, and by comparison, it's priced right. Otherwise, you wouldn't be purchasing it for that price. But the appraisal's job, or the appraiser's job, is to be the eyes for the bank, so that they know that they're making a smart investment in providing you a mortgage for the property. In the case it's a government loan, then that appraisal goes a little bit farther than a conventional loan. They look for certain condition issues that are even more stringent, if you will, than a conventional loan. Like with FHA or VA, peeling paint can be an issue. A roof is always an issue for any loan, but those things are looked at even closer when it's a government-backed loan. Okay. In the event that we get to the last minute and something with your loan changes, the rate, the fee, something like that, which doesn't happen very often, but if it does, the law says that you can't sign your closing documents for 3 days, giving you the ability to review the new terms of your loan. And so with that law being in place, then buyer and seller here are agreeing that if that were to come to pass, we would extend closing for that additional 3 days to give the opportunity for this Regulation Z, Truth in Lending Act timeframe to pass, so that we can then subsequently sign documents and get closed. So that's the financing contingency. We have these optional clauses that we add as well, like letting you know that square footage, lot size, encroachments, which mean like neighboring fence lines and things of that nature. The brokers can't verify those things. The seller might make certain statements, but ultimately, if you want to know how large the home or the lot is, where the boundary lines are, you need to measure, you need to hire a surveyor, that sort of thing. Parties don't normally hire surveyors unless it's really high dollar, every inch counts type of property, like waterfront or really expensive commercial property. Title insurance, we talked about title insurance being ordered, an Alta form of homeowners insurance is by default what is utilized. It's a good amount of insurance. Standard owner's coverage is actually a smaller amount of coverage. And so very rarely do we ask for a smaller amount of coverage, and it's very small in the difference in price. So we don't usually go there. And extended coverage would cover for certain things like boundary line encroachments. But the stipulation there is then you would have to hire a surveyor to do a survey. And so often people don't extend their coverage because it costs them more to accomplish the things that the insurance company needs in order to give that kind of coverage. So again, usually high dollar waterfront commercial, that sort of thing. Seller's supposed to clean the property, but there's no definition of what clean means except to remove all trash, debris, and rubbish from the property. So I will let you know that most of our clients end up cleaning their new home before they move in, just because everybody's standard of clean is different. Personal property, should the seller leave any personal property behind upon closing, this stipulates that it will now belong to the buyer, the new owner. This is not an invitation to leave junk behind that they don't want, or mom's old couch or a weight set or something like that. But what it does is it circumvents the law that would state that just because the home now belongs to you doesn't mean you own these things that are in the home. And so now, by law, you have to store it for them. You have to give them ample time and opportunity to retrieve it. That can be up to a couple months worth of time. It's just cleaner to say, okay, once this closes, seller, it's mine. Stay off the property. You can't access it and you can't get anything back. Okay. Utilities, we'll find out exactly what utilities serve, and we'll get that stipulated here. Insulation values only come into play with brand new construction. Otherwise, we really don't know what the insulation values are. Leased property, again, very rarely, but sometimes an owner might have, say, a propane tank or even a water heater that's leased. Security system is another example. If that's the case, then they need to disclose that to us, and we'll have to work out whether or not the buyer takes over the lease, or maybe the buyer negotiates to say, no, seller, I want that owned free and clear, so you need to buy that out. We'll work through that if there is leased property. In the case the property sits in a homeowners association, then we're going to want to collect as much information as we possibly can so that the buyer can see what is involved in being a part of that association, and see how strong they are from a financial standpoint too. That's really important. Some associations, many of them these days, have a transfer fee. So when somebody buys and sells and moves in and moves out, there's a fee involved. A lot of times that's because they're professionally managed, and so there's labor involved in creating a new file for a new owner and closing out the old file and all of that. So by default, we like to specify that the seller is going to pay that fee, but it also depends on what it says in the homeowner's documents and the association documents. They may have a rule in the association that says, no, buyer has to pay that fee, and whatever that says, that dictates for sure, okay? Excluded items, so if there was something that's actually part of the real estate, but the seller intends to take with them, like the prized rose bushes in the garden, they would have to specify this in the agreement. Again, no matter what they said in the listing, if it's not here in the agreement, it doesn't exist. Very rarely is anything excluded, but that is what this section's for. And then home warranties. So there are independent third-party home warranty companies that you can purchase a warranty from that would cover systems in the home like heating, electrical, plumbing, appliances, things of that nature. They generally cost in the vicinity of $400 to $800. They cover for a year's time. And they're nice to have. They're like any insurance. It's great if you end up needing it or using it, and it costs money or feels like it costed money if you don't end up using it. You can ask the seller to buy one of these for you. In some markets, they actually, depending upon the circumstances, they might be offering to purchase one for you as part of the marketing of the property, in which case we want to make sure that it's specified here in the agreement so that it's binding. But at the same time, in a competitive market, this may not be where you want to do your negotiating. You may want to focus on negotiating on price and other major terms, as opposed to asking the seller to buy you a warranty. But you as a buyer could purchase a warranty. Okay. Here's the disclosure of lead-based paint form. So again, only with homes that are older than 1978, this standard form is basically informing the seller of their legal obligation to disclose to the buyer their knowledge or lack thereof of lead-based paint in the home. You can see they have to check a box. They know or they don't know, and they have reports or don't have reports about lead-based paint. And then the second page is actually your opportunity as a buyer to either accept the opportunity to do a risk assessment, hire a company to come in at your expense to do an assessment of the home for lead-based paint, or you can waive that. Even if you place the check box in the accept checkbox, doesn't mean you have to perform it. It just gives you the right to do so within a certain time frame. I rarely have a buyer do any testing like that because it's usually very expensive. We, by law, have to provide you a pamphlet on the dangers of lead-based paint, and as you read through that pamphlet, you may discover that the dangers aren't as severe as you might think because certain circumstances have to exist in order for it to be a hazard. But at any rate, that's what this is intended for. Identification of utilities, remember those lien right utilities. We're going to specify and make sure that the seller verifies these are the utilities that have lien rights so that the closing agent can get that settled at closing. In the case that the home's water is served by a well, whether it be an individual well or a shared well, then we include this well addendum that allows for us to help you to go through the process of testing for water purity and making sure that everything is working right with the well system. Because as you can imagine, a property without adequate supply of water is not a very usable property. So we actually give a pretty significant or look for a pretty significant amount of time to do that because it can take time to draw samples. You would want to, we advise you hire a well expert to come out and look at the entire system, pump and all that. A brand new well pump can be thousands of dollars to replace. So we want to make sure that that is sound, and a home inspector is not necessarily specifically trained in that. So he's a general inspector, and so it's advisable that you have an expert come and check out the well. They would draw water samples, take it to a lab, and then we'd wait for those results, and that's why we need a little extra time on that. So this is an example of a septic addendum. This happens to be a Thurston County addendum, and depending upon the county that we're working in with a particular property, there might be a different addendum. This one's for Thurston County, and it basically says, seller, if you have not had the septic system pumped within the last 12 months, you are obligated to do that. You have to use a pumper that is certified with the county to do so. They have to then report to the county those findings, and they're going to be applying for what, at least in Thurston County, is called the time of transfer certificate or certification. In other counties, it's called the operational and maintenance certificate. They have different terminology, but it's the same thing. Basically, the findings have to be recorded at the county, and then they issue us the report for you to review, and you'll have time to review that report and to say, whoa, wait a minute, that looks like something's wrong here. You can talk to the septic company, but ultimately it's a protection for you and for your earnest money. If something doesn't look right, we can terminate and get out, okay? The title contingency. So our boilerplate purchase and sale agreement says that seller will provide marketable title unencumbered by loans and liens and things of that nature, but it doesn't necessarily mean that it's completely desirable title to you. There are going to be things that are recorded against title that may or may not affect your use of the property, but you may not desire it. Like, for example, easements. Let's say you have a larger acreage property and there is an easement for the benefit of a neighbor to be able to pass through your property to get to another property on the other side. That doesn't make it unmarketable, but maybe you don't like that element. And so this contingency allows for you to review the title report that we get from the title examiner and go, whoa, I don't agree with this. Seller, you need to rectify this, get this removed, or I don't want to purchase the property anymore. Just a little added protection. Not many times do we have title issues. Usually it's pretty clean. Inspection. So this is probably the most powerful of all the contingencies. It is basically a get out of jail free card, because the intention, of course, is for you to hire a licensed structural and pest inspector to do a thorough examination of the property. and decide whether or not you still want to purchase it. Okay, but there is no requirement for you to give the seller any explanation as to why you might want to terminate. You could simply say, I'm terminating under my rights under the inspection contingency, and you don't have to tell them why. The intention is that you do an inspection, and usually what occurs is you get that inspection report from the inspector, and there may be some things that concern you. So then we go to the seller and we say, seller, for us to continue with this process, we need you to rectify these things in these ways. Okay. The nice thing to know is that when you make these requests of the seller, they can't respond saying you can't buy my house anymore. Okay. They don't have that right. Only you have the right to terminate, and you still retain that right if you make your requests and they deny you, or they won't do exactly as you ask them to do. But the intention is for us to go through a process of negotiation if it's necessary, and try to get what needs to be rectified corrected. Okay. Generally, we look for a 10-day inspection contingency. However, in some competitive circumstances or fast-paced markets, sometimes that can be reduced to 5 or maybe even 3 days. We got to hustle to get an inspector out there. But sometimes sellers, if they have the advantage, they don't want to be held off the market any longer than necessary in the event that you're ultimately going to terminate. They'd like to get back to market and be able to put another buyer in contract. So it might be shorter than 10 days in your particular circumstance. If your general inspector comes in and says, okay, well, here's the inspection report, but I looked at the roof, it looks like it might be getting older. I'd recommend a roofer take a closer look at that. Or the heating system, it's kind of noisy. I think you ought to have an HVAC company look at that. We refer to those as additional inspections, okay? And my advice is that you always keep the inspection process in your court, okay? If the home inspector says, it looks like this needs to be looked at, sometimes they'll even say, seller should verify this. Well, no, you should. You as the buyer have the responsibility to yourself to understand all the conditions of the property. And if you turn it over to the seller and say, seller, you investigate this and let me know that it's okay, well, now you lose control. You never know how they're going to handle that investigation and who they're going to get to do that investigation. That's why we do additional inspections. And so we can call for an additional amount of time, usually 5 extra days, for you to call in other experts to do further evaluation before ultimately then we go to the seller and say, this is what we found, this is what we want corrected, and this is how and who is to correct it. Okay? So it's a long form because it's a lot of back and forth and the understanding of timeframes and all that. It's our job to manage that for you. And that concludes the addenda that are attached to the purchase and sale agreement. Again, certain circumstances, some of these addenda won't be attached. Other unique circumstances, there may be other addenda that are attached. We've got a form set of about 150 different forms that we could possibly use depending upon certain circumstances. But I hope this gives you a good overview. And again, if you have any questions whatsoever and you just want to discuss this before we move forward, don't hesitate to reach out and let us know. All right. Thanks very much for your continued trust.